to our International Construction Law Conference. Nothing to worry about. I gave my welcome this morning, so I really just am going to speak for 30 seconds. Just to welcome back everybody here in Bush House and online, and to welcome on behalf of King's and on behalf of the Center of Construction Law and Dispute Resolution, Paula Hodges, partner Herbert Smith Freehills, but here in her capacity as president of the LCIA Court. We are very pleased to have her here. Absolutely delighted and very grateful to her for taking the time to be with us and sharing her views on resolution of disputes in the construction sector, which is what we all do. And now, without any further ado, I hand over back to James to introduce Paula properly and review sharing the event. Thank you, James.
Thank you, Renato. Welcome back to the afternoon session, and my thanks to all you steadfast online delegates for continuing to tune in. Again, a reminder on questions. If you're online, please do ask questions on the Q&A function on Teams. I'm monitoring the questions as they come in, and I publish them, and then I will put them to Paula and subsequent panels during the session. For those delegates here in person, please also ask questions. I know you are a little bit out of practice at this, but raise your mitt, and I will clock that you have raised your mitt, and then we can hear your question. As I sit here on the edge of London's business district, the so-called City of London, it's apparent over the past few weeks that there's been a steady return of the commuting populace, and indeed the United Kingdom and many other jurisdictions are tiptoeing back towards normality. Appropriately, therefore, we start this afternoon with our keynote speech, which is entitled Construction Disputes in the Wake of COVID. This session will address, amongst other things, how the global construction industry has been impacted by the pandemic, the types of disputes in the construction sector that we can expect to see in the coming months and years, and more broadly, what the arbitration landscape may look like for construction disputes in the future. There really can be no one better placed to address us on these matters than Paula Hodges QC. Paula heads Herbert Smith Freehills' global arbitration practice and has over 30 years' experience of advising on international disputes, particularly in the energy, telecommunications and technology sectors. She specialises in international arbitration and has represented clients in many jurisdictions, including London, Paris, Geneva, Zurich, Stockholm, the US, Canada, Dubai, the list goes on, and in ad hoc arbitration and proceedings under the auspices of the major arbitral institutions. She also sits as an arbitrator. Paula has been closely involved in several high-profile cases before the High Court in London and has also appeared before the Court of Appeal and the House of Lords, now of course the Supreme Court. Paula studied law at the University of Cambridge and graduated in 1986 with an MA in law and became a QC in 2014. And most recently in May 2019, president of the LCIA Court. Paula, over to you.
Thank you very much, James, and I'm delighted to be here today before a live audience. This is the first speaking engagement that I've had since March 2020, when there have actually been human beings in the room with me. So thank you very much for joining me. As James said, my theme today is the construction industry in the wake of COVID. And I think I warmed to the theme a little bit too much over the last few weeks and contracted COVID myself. But I'm pleased to say I did emerge from self-isolation on Monday, and I'm delighted that I'm able to be with you today, but beginning to creak a little bit, like I think some of the industry sectors, having undergone the pandemic personally. But look, it is true to say that over the last 18 months, the construction industry has experienced a very turbulent time. Many construction projects around the world have been impacted by government-imposed lockdowns, workforce shortages, border closures and export restrictions. And the responses to the pandemic have in turn led to delay, disruption, shortage of materials, cost overruns, albeit that has occurred to varying degrees in different places at different times. But of course, where you get delay and cost overruns, etc., you also see disputes, because people then try to work out who has the legal financial responsibility for the financial challenges that have emerged. And there's no doubt that we are beginning to see a great number of disputes in the construction industry around the globe, but perhaps it hasn't hit the peaks that some of us might have thought it would have done by now. And why is that? And I think there's a number of reasons. Certainly in the early stage, the first 6 months or so, parties were far more open to trying to find a solution. They were mediating and using other forms of ADR. I think there was a sense of, we're all in this together, let's sort it out. But of course, the longer the pandemic has endured, so the problems have increased. And I think that willingness won't be there forever. But at the moment, of course, we still have government measures in countries worldwide which are forestalling perhaps the more severe consequences of the pandemic. And so there aren't as many formal disputes as one might have expected at this stage. But it could be that these disputes are just being deferred. In its report earlier this year, the UK Construction Leadership Council, best known for securing its deal with the UK government for the construction sector, predicted that there'll be a rise in the number of claims in the next 12 months or so. And it suggests that this is down to a combination of factors. It describes it as a perfect storm of a negative economic environment, EU exit, reduced construction market activity, the end of government business support schemes, the introduction of reverse charge VAT, and a significant increase in the number of claims across the supply chain. Not a very pretty picture, I have to say. But the anticipated rise in disputes will not simply be felt in the UK, not just in one jurisdiction alone, because I think we'll see the same sort of picture, maybe not Brexit, but we will see government schemes coming to an end. We will see parties resolve hardening to find a financial solution to their problems. And certainly with the international crossover within the construction industry, with multinational construction companies doing work in many different continents across the world, I think we'll see the potential for more disputes to arise with people coming out of the pandemic in varying stages and in varying conditions of financial health or otherwise. So today I want to look at what's happened to the construction industry across the world, the sorts of disputes that we might see, obviously delay and disruption claims, insolvency related disputes, but also disputes relating to the shortage of materials and workers. And of course, because so many of the major construction disputes tend to be resolved by arbitration, I also want to look at how the arbitration sector has fared during the pandemic and how the landscape for resolving disputes by arbitration may look in the future. So turning to the practical effects of the pandemic on the construction industry first, and the most obvious fallout is obviously the delay that so many projects have suffered since March 2020, either because of government-imposed lockdowns, sickness, other COVID measures, and of course, social distancing. For example, in jurisdictions such as Singapore and Malaysia, almost all construction work was expressly prohibited as part of the most severe lockdowns. Whereas in the EU and India, a tiered approach was taken, with essential construction work being allowed to continue during the lockdown periods. To take one example, the global CEO of Australia-based Lend-Lease has stated that the impact of social distancing protocols across its company's sites has led to a 16% decline in revenue and a 9% decline in hours worked. I was surprised actually the 9% wasn't higher. The World Bank has also estimated that 256 projects in developing countries have been disrupted or cancelled due to the pandemic. And they give us two examples, projects in the Philippines and Colombia. Even here in the UK, where construction projects were permitted to continue during the lockdown periods, the new guidelines and logistical challenges have still caused delay. And EDF's Hinkley Point project is one example of that, and it's apparently been delayed for up to 6 months. But of course, there's been a reduction in productivity as well. And so for longer term problems, it could be that the delays have still not crystallised. So given the significant financial impact of the pandemic, it is anticipated that there will be an increasing number of insolvencies, unfortunately, in the next year or longer. Interestingly, of course, during the pandemic, the opposite happened. And certainly, to give you an example, in the UK, the number of insolvencies fell drastically. In the construction industry, there were 2,000-ish insolvencies, which is the lowest for a decade, and compared to over 3,000 in 2019. And the same thing has been seen in many different countries across the world. But I think there are a number of reasons for that. First of all, many countries made changes to their insolvency regimes to protect companies from going bankrupt, the UK included. So, for instance, countries like Belgium, Italy, and Spain enacted laws which froze their insolvency regimes so that you could not declare a company bankrupt. Other countries, such as Singapore and Australia, increased the debt threshold before a company could be declared bankrupt. Now, the general view, at least in the UK, is these unusually low insolvency figures, unfortunately, will not last forever, because a lot of it is down to the billions of pounds the government has pumped into the construction industry and many other business sectors through the furlough scheme, government-backed loans, etc., etc. Indeed, the British Business Bank says that the UK construction industry received the highest proportion of government loans compared to all other sectors. So as a result, it is quite possible that we will see more insolvencies as the UK government and other governments around the world withdraw this additional support and loan and deferred tax payments become due. Indeed, the UK furlough scheme is also winding down and will finish at the end of this month. And I think that could be quite pivotal for the construction industry, because according to HMRC, just under 130,000 people in the construction industry have been on furlough. And of course, you see similar signs of support across many different business regions. In the EU, there is the EU 750 billion recovery fund that redistributes funds from countries that fared better to those that are struggling. In the US, there have been many different subsidies, including the Paycheck Protection Program and stimulus checks, which help to maintain wages. in various industries. The Hong Kong government introduced a subsidy to help construction companies pay their long-term casual workers. So although it's hoped that many companies will have not just taken advantage of the various support schemes that have been in effect to keep them going through the pandemic, but that they will also emerge sufficiently strong to keep going, I don't think it's anticipated that there will be success across the board, and that unfortunately more insolvencies will appear. Now, as most of you will be aware, there has also been a global shortage of construction materials, such as timber, steel and plastics, due to increased demand on the one hand and reduced production because of the pandemic on the other. And this in turn has led to delays in supply, but also increased costs. Some larger players have been able to stockpile materials, and so the general view is that it's the smaller and medium-sized companies that are feeling the pinch more. But given the predicted effect of these continuing shortages, it is thought that it's going to be felt higher up the supply chain too, with some of the mega projects also being hit. And of course, there are numerous countries around the world, including our own in the UK, where the governments are saying that they're going to build their way out of the economic downturn. In the UK, we have the Build Back Better scheme, and then the mega projects such as HS2 and the Thames Tideway Tunnel. In the US, President Biden has said he wants to inject up to $1 trillion for the construction of roads, bridges and other works. China also has similar infrastructure campaigns and is saying that it's going to spend up to 17.5 trillion yuan, which is about 2.47 trillion US, in new infrastructure projects. On the other hand, though, there are worker shortages. In Singapore, the impact of COVID-19 on the construction workforce has been significant. And for a number of months during lockdown, the whole construction industry came to a virtual standstill. Of course, the tighter border measures don't help either. The same is true in China. The China Construction Industry Association has stated that labour shortage was one of the main reasons for the disruption of China-related projects. And ports in China have been closed due to reduced capacity. And of course, the UK has experienced additional challenges on top of the pandemic due to Brexit, with the construction sector losing a quarter of its EU workforce in 2020. So I'm sorry to be painting such a bleak picture, but when you do actually stand back and think about the impact that the pandemic has had on the construction industry in so many different ways and in so many different regions, you realise that there are lots of bumps in the road yet to come. So to recap against that background, questions are bound to arise as to who is going to bear the financial consequences of these various issues. Does the contract provide a solution? Do you have to look to the general law that applies to a particular project to find a way out? And of course, many pre-pandemic contracts will not have dealt specifically with the consequences of a pandemic, and assessing how the relevant construction addresses the risk of unavailability of materials, the risk of losing the workforce, the risk of delay and disruption is going to be key. So the disputes outlook has been quite uncertain since March 2020. And certainly it's fair to say that the focus of the construction industry has been on trying to resolve disputes rather than to encourage parties to fight where they need to. And certainly the Construction Leadership Council I mentioned earlier has published a managing contractual disputes and collaboration guide to try and help parties work their way through these issues. In Singapore, the COVID-19 Temporary Measures Act also provided relief to parties experiencing difficulties because of the pandemic and introduced various cost-saving schemes for both private and public sector projects. The Malaysian government also introduced a temporary legislative freeze on the ability of parties to exercise their rights in relation to counterparties' inability to perform their contractual obligations, and established a mediation centre to try and encourage people to resolve the disputes. Again, we've seen similar steps being taken in China. Those seem to have varied from province to province. So, for instance, in Guangzhou, the measures have been trying to limit the increase on material costs, whereas in other provinces such as Shanxi, the local government has actually specified the quantum of pandemic prevention costs that can be charged per project. So where formal disputes have already emerged, they have predominantly been focused on whether existing contractual provisions, such as force majeure, change in law, could provide a solution, or have fallen back on the general law. So in the UK, concepts like frustration have been brought into play. Certainly, a report published by Arcadis, who will be familiar to a number of you as cost consultants, so looked at the causes of disputes in the last year or so, and certainly of the top 3 clauses, it came down to force majeure and other forms of disruption due to COVID-19. Now, of course, since the pandemic broke, parties have been trying to introduce new provisions into their contracts in order to try and avoid uncertainty with regard to the allocation of risk going forward. And there is now new guidance for amendments to the JCT design and build contracts and others. However, as time passes and not all contracts will have these sort of new fixes, it is thought that attitudes will harden, especially as delay and disruption to the supply chain continues. And so this does suggest that parties will look to start more formal dispute proceedings going forward. But despite the unprecedented nature of the pandemic, the disputes that are likely to come up, I think, are very similar to what we've seen in the past within the construction industry. Already common causes of disputes are delay and disruption, financial hardship, shortage of materials. These are common disputes that arise in complex projects, and I think they will come to the fore again. And of course, because of the economic impact of the pandemic, there'll be claims that lead indirectly to a formal dispute because of the pandemic. So, for instance, if there are margins being eroded, it's likely that bonds will be called on, and there will be various other financial disputes that will occur too. Of course, insolvency-related disputes are likely to arise as well, but I realise that's going to be covered by another panel in greater detail later. So how will these disputes be resolved as and when they raise their head? Well, international arbitration has always been a very popular mechanism for large, complex construction disputes with an international element. I know I'm probably preaching to the converted here, but obviously the advantages of arbitration is the powerful enforcement framework provided by the New York Convention, party autonomy, flexibility and limited regulation. And I see those factors as remaining attractive for post-pandemic disputes, just as they will have done before COVID. And I would say that despite the many challenges created by the pandemic, I think the arbitration sector has, one could say, been forced to adapt, but actually has embraced adaptation and has certainly tried to move with the times. At the beginning, there were temporary measures put in place. Not everyone embraced virtual hearings. Some people postponed their hearings, and certainly the various arbitral institutions were issuing emergency guidance as to what should be done. But very quickly, certainly in my experience, most parties, arbitrators moved to virtual hearings. Electronic communication became the default. People have started signing and circulating awards electronically unless there's a real reason for it to be in hard copy. And I think overall the arbitration sector has adapted incredibly well. Certainly, so far as the LCIA was concerned, we had some refresh rules on the stocks ready to publish in early 2020, just before the pandemic hit. We decided to hold on to the draft rules and wait to see what happened. I must admit, very pleased that we did that, because although publication of the rules was delayed, it enabled us to actually include express provisions allowing arbitrators to call for technology to be used throughout the proceedings, to hold virtual hearings, to issue awards electronically. And also, we saw that parties were becoming even keener than ever on having efficiency and cost-effective mechanisms for resolving their disputes at the forefront. And so we made the LCIA 2020 rules much more express in terms of the bespoke procedures that arbitrators can introduce in order to encourage that efficiency. So one of my favourite provisions is early determination, very common law concept, but if it can be shown that a claim, counterclaim defence is legally unsustainable, completely without merit, the arbitrators can dispose of that claim or counterclaim early in the proceedings and don't have to grind through the whole dispute in order to get to the end result. And the LCIA wasn't alone in introducing new measures. All of the major institutions have been seen to adapt. So I do think that arbitration will continue to be a very helpful way of resolving disputes as when they appear. The question is, for the construction industry, will virtual hearings remain the norm? Will they become the preferred mechanism of dealing with disputes? And I think that's a very interesting question. I think for procedural hearings, absolutely. Small, medium-sized disputes, yes. But where you have multiple different nationalities involved, complex technical issues that need to be explained, I think it will still be best to have people in the room. It could be that I just prefer cross-examining in person, but I think most of the clients are telling me that they want that important high-value dispute to be determined in person at the end of the day. So we will just have to wait and see. But I think I've slightly overrun my time already, so I'm going to hand back to James now.
Thank you very much, Paula. Just a few questions. We're a little over time, but just a few questions. Obviously the LCIA publishes statistics annually as to what types of arbitrations it's dealing with, but you will be privy to the latest information. Noting your observation on the lag between the pandemic and arbitrations being commenced, are you starting to see a shift within the LCIA towards more arbitrations?
Well, certainly, don't want to sound too pleased about this, but the LCIA had its best year ever in 2020, and you'll have seen the statistics from most of the major institutions. I think everyone saw increases across the board, and certainly during the course of 2021, the numbers are again up on last year. Certainly in the construction sector as well, numbers are up. Certainly so far as the LCIA is concerned, the main sectors as well as construction have been energy, natural resources, mining, but also the financial services sector. I think the banks tended to veer away from arbitration, preferring their home court jurisdiction. But I think as they have invested more broadly and in projects all around the world, they realise the benefits of arbitration. But also with the amount of private capital now going into projects, private equity companies, that has also meant that there's an uptick in arbitration in those sectors as well.
All right. We are enormously grateful to you. As you said at the start of your presentation, you have yourself been the victim of the pandemic or COVID and flung the organisational committee into panic a week ago when you told us this, or 2 weeks ago. We know you're still recovering. We're very grateful that you made the effort to join us today. Please join me in thanking Paula Hodges QC.